much for joining the session well in advance, and you have attended other sessions also and actively participated in the question answer also and answered some of the key questions. So
Okay.
thank you so much.
My, my prime objective of life to keep me happy. I should be connected with the people through the knowledge I have gained in my working.
Thank you so much. We will start exactly at 2 o'clock.
Okay,
Let the
okay,
people join. We
okay,
have 10 minutes more, sir. Okay.
okay. I'm getting
So
so many messages that you want to join. So should I allow them? Or someone wants to join
uh,
this call. What should I do
uh,
that?
yeah. Actually, I made you co-host. That's why you are getting the
Okay,
messages.
okay, okay.
Okay. So that you can find out it easy enough to present your work, your presentation. So I made you as a co-host.
Okay. So I should allow them admit or deny entry.
Yeah, it's a work, sir. So our organizing team is already doing it.
Okay, okay. So I
There
need
are
not.
4 or 5 people who are already doing it. Don't worry.
Okay.
Organizing team is ready. Mr. Ritesh.
Yes, sir.
Please go ahead.
Organizing team, please go ahead. Dr. Shrikant?
Yes, sir.
Yeah, please. Please give the warm welcome to our guest.
I would like to invite Dr. D.D. Patil, sir, to give a brief introduction of Dr. Singh, sir.
Good afternoon to one and all present here on behalf of SPCE Mumbai and HSM SHGV CUT Bhusawal. I, Dinesh Patil, coordinator of 5-day national level FDP, welcome guest speaker, faculties and participants. Now let's start our FDP 6th session by introducing our resource person. I heartily welcome today's eminent speaker, Dr. Singh, sir. It's a great pleasure for me to introduce you for this session. Dr. Singh did MSc in 1985 from Jivaji University, Gwalior, and PhD in Organic Chemistry from Meerut University. Dr. Singh have 34-year service exposure of various kind. Initially worked as chemist in pharma industry and scientific officer in National Test House, Government of India, and finally about 23 years in Patent Office, Government of India. Dr. Singh joined Patent Office in 1999 as an examiner of patent and design, and then evaluated to assistant controller, deputy controller, and superintendent as a joint controller in July 2021. Dr. Singh visited World Intellectual Property Organization, Geneva, Switzerland in 2005 and Japan Patent Office, Tokyo, Japan in 2010 and 2015. Dr. Singh did 6-month research fellowship of World Intellectual Property Organization, Japan Patent Office in 2010. In Patent Office, Dr. Singh was actively involved in various responsibilities of importance like National Informatics Center, coordinator of modernization project, in charge of publication section in early time when established. Dr. Singh remained designated Center Public Information Officer for Patent Office, Delhi, and proved the most successful Center Public Information Officer for a long time. Dr. Singh was key person to establish Aadhaar-enabled biometric attendance system in all offices under Controller General of Patent Design and Trademarks. Dr. Singh was appreciated by stakeholders for his grievances resolving approach, including his contribution for disabled person as disability officer. Dr. Singh did significant contribution in traditional knowledge digital library project as patent expert. Dr. Singh recently got registration as patent agent with Office of Controller General of Patent Design and Trademark to practice before Controller of Patent under the Patent Act. Now, sir is going to spark us on topic optimization and further streamlining of IPR, intellectual property right registration, and granting power of controllers. We are very happy, sir, to have you a resource person for 5-day online faculty development program. Now I would like to invite respected Dr. Singh, sir, to start the session and address our participants. Over to you, sir.
Thank you very much, Dr. Dinesh Patil ji. I'm very much familiar with this name. My colleague was in Mumbai Patent Office, Dr. Dinesh Patil, who is now head of office and looking after the technical work in office of CGP DTM. Very laborious person, very intelligent person, very dedicated person. I believe the Patils are very dedicated people of Maharashtra. So congratulations to you all.
Thank you,
And
sir.
how to start the presentation? Should I make it?
Yes, sir. You share your presentation.
Okay. So confirm me it is equal to your window. I'm starting with.
हम डाउनलोड कर दे रहे हैं आपने उसको एडजस्ट कर दिया
You can see. I'm trying to share my window. Here now.
Yes, sir, it is getting shared.
So
Pramod Patil is presenting.
okay. So I have to open at this place only.
So at the bottom, you will find there are circles. In one circle, you will find the upward arrow in a rectangle.
Yeah, present now.
Yeah, you please click that.
Okay. So I have opened my presentation on desktop, but maybe
Yeah, you please click this. Then
I-
you go to it,
I have
your
to-
entire screen.
I have to share my entire screen only.
Yes, yes. It will ask you it will give you three options. Select your entire screen. Click it.
Share my entire screen is
As you click it, you will get your entire screen is getting selected, and now
is my presentation.
share it officially.
Stop sharing presenting.
Please.
Stop presenting now.
Yeah, it is getting presented, sir. It is perfect. Perfect. Getting presented.
We are able to see my PowerPoint.
It will take some time. Please wait.
So is it available now?
It is getting. Your presentation is not available now.
Is it now?
Again, follow the same method. Again, follow the same method.
Okay. Pencil. Present now.
Yeah. Select entire screen.
Entire
You will get
screen.
you will get one window, and at the bottom right corner you will get option tab share. Click it. Bottom right corner of the window.
Share.
Yes, it is getting presented, sir.
Is it coming?
Now you please click your presentation. It is getting presented now. You please click your presentation. Go to presentation and click it.
Oh, stop.
Don't stop. Don't stop. You go to presentation now.
Go to presentation.
Presentation. Your presentation.
Okay.
Please. Yes. Yes. Now.
It is available now.
Yeah. Now it is visible. However, you have to keep it in the presentation mode.
Okay. Now.
Yes. Presentation mode. Yes.
So I must start with congratulating to you all because I see that first time I am seeing that so much participation in online program.
Sir, there are total 1,066 registered participation from 21 different states of India.
I was surprised with 250 itself because
Here we have the limitation for the Google Meet 251, and then remaining participants are on the on the YouTube live streaming.
Great. So it's great contribution of you all, coordinators and collaborators that
Thank you, sir.
you are doing this excellent effort.
And the entire program is being given free of charge to all. It's a service to the nation.
Very good. With the same spirit, I am always available to my pupil, and somewhere I have written also free and fair consultancy. So good, and I'm noticing that there are two medical engineering colleges and other institutions which are involved to help people to make aware about the IPR and specifically in patents. And very good people you have chosen for your program. Dr. Ujjwala Haldankar, you have started from first day. She was one of the an excellent officer in when I was head of office in Mumbai. He was one of the excellent officer of my team.
Yes, sir.
And again, I have heard Mr. Tapan Brahma and Dr. Sikha Rastogi. They have explained. They have explained the subject matter with so many court cases and so many examples to you all people that really it is worthy derivations to help the esteemed people of community, scientific community.
Thank you, sir.
So topic you have given me, optimization and further streamlining of IPR registration and granting. So, and reflections to power of controllers. So, I have mentioned here for you all. I'm always available for you all people, those who keep interest in patents. And I'm audible properly?
Yes, sir.
Yeah.
Great.
So I always try to connect people by the purpose and the topic where we talk. So I gone back to the meaning of optimization, so that we can understand the things purposely, not simple dictionary meaning or something like that. So in the Hindi meaning of optimization is anukulan. This means that हमको सबको अपने आप को अनुकूल करना है पेटेंट के बारे में जानकर, और जो इन्वेंशन डेवलप वर्ल्ड ओवर द वर्ल्ड हो रही है उनका पार्टिसिपेशन करने के लिए. If you go by simple meaning, dictionary meaning of optimization, an act, process or methodology of making something such as design, system or decision and fully perfect, functional or effective as possible. So first of all, we have to understand that what kind of audience I am, the person who are listening me, that what kind of people they are. If they are students,
sir, these are the faculty members from the various institutions in India. There are the researchers, there are the practitioners, there are the innovators.
So
if faculty member,
if they are faculty, if they are faculty member, they have to optimize this knowledge as to work in their own laboratories about the possible IPR generation and to teach other students about the IPR. If they are a student, then they have to take it as how when they go, because as a student they cannot do much as to the technology, because for any research and development there must be required a laboratory or workplace. So when a student will go to higher education, he may keep in his mind that how he can contribute to develop in the matter of patenting. Patenting means a knowledge which by which you can make money and by which you can be ahead of or resolve the problem of society. Because it is mentioned in our act that if you do any value addition or in the existing technology that is of more economic significance, that will be patentable. So maybe there are so many technology in different fields. Maybe it is mechanical engineering, maybe it is electronics and communication, maybe it is in drug, maybe it is in food. So suppose if some technology available at the higher cost, so what contribution you can do as invention to bring the cost down? Suppose it is a machine for this excavation of earth. So JCB are well-known machines, but they are costly. So how can a mechanical engineer who is working in a industry try to develop some machines which are not that much costly as that of JCB machines? Suppose some person is working in food industry, so he can find way that packet of chips, if it is costing 20 rupees, how can we develop machines for that, or how can we develop methods for that the cost may be optimized to the minimum level. So like that, I'm connecting this word optimization with the pupil audience of television today. And next word is streamlining. So all that what I was just telling to you, all that is to streamline the things. If you go for the as per dictionary meaning, to improve the effectiveness and organization such as business government, often by making the way activities and perform simpler. So how to improve effectiveness? If a faculty wants to make file a patent or want to contribute for this country in technology, so how they can make it smooth? So for little knowledge, one thing that first of all they should understood the things, the procedures how to get patent, and the purpose of the patent. And they should, if they go simply to file patent just to have a document, just to get it granted by somehow, some way. So that may not be, I don't say that it will effectively organize the things. If they go for some society problem, and they go to some industry before suppose some faculty member have to get registered some student or some project work or some PhD work. So they may ask students go to nearby industry and collect the informations where the problem exists in the industry. And on that basis, they can start project work to further complete the academic requirements of the PhD or some this project. Someone may confirm I'm properly audible?
Yes, sir. Please continue.
Okay. So I have connected these two words of this optimization and streamlining with the purpose of this deliberation. And how you do that? So simply because as of today, you have got sufficient knowledge about the patent at least. Dr. Haldankar has given you all the way how patent is protected. It's not that difficult. Simply, first of all, is difficult is to get ready for the patenting. So filing is not difficult, not at all difficult. So I have taken this screen, and after taking this screen, this idea has come to my mind with the screenshot of our honorable Prime Minister of India, Modi ji. Sabke saath, sabka vikas, sabka viswas, sabka prayas. So means only with the efforts of everybody, and belief of everybody, the development will happen, and that development will be for all, not only for that person. Though, I mean, in India, we believe earlier that education is not for commercialization, but we see that the commerce so generated in developed countries like America, China, and Japan, etc. They are all developed because of the property of their IPR. So this time it is not for free of cost, but you have to be protected before that. For that, you need to learn much about this patenting. So for that, for your prayas, I can say that you can go through this website. This website is so comprehensive that you can any faculty member, any student, any person can make aware himself about this system. Even presentations are there for IPR awareness. And even this, my point is, are you able to see my pointer also? Hello?
Yes, sir.
Yeah, are you able to see my pointer also?
Yes, sir.
Okay, so this link is available for your comprehensive e-filing, from where anybody can e-file. Nowadays, we have made it so easy that only e-signatures, same time you can get, and you can start filing. And also there is almost 10% reduction in fee also if you do e-filing. However, this is not compulsory. You can also, because suppose in case of provisional specification, suppose if you have come, because I see that one student has asked the question also, can we patent idea also, sir? Can we patent our idea for design? So for any idea, we suggest you to file a provisional specification. And that provisional specification is simple, very simple, one paper. You can file form 1 as per our this act rules, and simple paper you can write down the idea what you have purposed to develop as an invention. So at least you will get a date of filing. Later, within 12 months, you have to file complete specification, but that you can do in one paper itself. And public search is also available. You can even see that what are the patents filed by other people or granted to other people in the subject matter of your interest.
Oh, acha. Oh.
Okay. Is there any question regarding this? Oh, my mistake. There was. I am listening some audio. Please confirm if I am audible. Because I have doubt.
You are audible, no problem.
I have doubt.
Yes, sir, you are audible.
Okay. Because sometimes I have doubt in my internet connection.
You are audible, sir. Please continue.
So, my purpose to show this slide was that everybody who is, attending this presentation must go through this website and try to explore the portions and material available for of his interest. And I have taken another shot from this public search link of this slide. This so many attributes are available where you can do e-filing, you can make payment of your patent agent fees. You can also see WIPO EPCT link also. You can also file trademark application through e-filing. And dynamic utilities are there. You can see expired patent. You can see the disposal of applications. Every day we are dynamically we are first of its kind. Indian Patent Office show the disposal of patent application per day. Suppose somebody has disposed application at 115, 120, you can see him in this link that in which subject the application has been disposed for FER or for grant. Everything is available. So many useful attributes are there. A status you can see about patent, design, trademark, etc. There is e-register also. Earlier, there was a system to inspect register by paying fees to office. But nowadays, it is in public domain, and you can see patent register of anybody's if you know the patent number. And purpose of that seeing register is that you at least you can understand the topic of the patent, the address of the patentee, and the position of the patentee, where is some license is granted in this, where some assignment is taken in this or not. So everything is available in patent register. So now this is next screen for patent search. There are so many attributes here like titles, abstract, complete specification. You can choose any key field and then search for your patent of your of your interest, and you can see each and every document filed in that file. So from there you can very much learn that how I should file, what are the basic requirements, how other people do that. So if you see that, I'm sure that everybody is so intelligent nowadays, and they can learn from themselves. However, I can't say that this will take away the need of the patent hiring a patent agent, because patent agents are so required, because this is a specific field of work, technological work, which it's not it's useful always, but not compulsory. But it's in the benefit of the person who is filing patent, because you see, drafting patent application is very tactful subject. Suppose somebody has this is an actual example, that when somebody invented the needle, stitching the cloths, stitching two pieces of the cloths, he has described his invention as he has invented a wire having sharp end, one end as sharp and a hole at the other end, which can be useful to stitch two separated cloth together. But when the needle for this sewing machine were invented, so situations were different. That the sharp end of that wire was having hole also, not at the top of the wire. So if that time that applicant would have drafted his application or his claim that I have invented a wire having sharp end and hole on the body of the same. So at that time, by writing this language, he would have protected the coming invention, or say that he would have been able to take royalty from the person who has further invented the sewing machine needle. So this is how the importance of drafting this claim and use of patent agent is significant in this system. So now I should take over my other part of the deliberation, the power of controllers under the Act. So I say those not actually as a power, but I say that provisions under the Act to help the pupil or to help the user to prosecute in a comfortable way under the Patent Act. So if I go through by reading this section 15, so this power gives this gives a power to controller to refuse or amend application. So I don't say that controller should think that it is his power to refuse, because you see, if you go by the line by line, power of controller to refuse or require amendment specific, etc. in certain cases. So not in all cases. In certain cases, he has to do that. He can do that. But in practice, we see that amendments are happening in each and every cases. That I say because it may be because of some professional reasons that I don't know why people draft initially there is specification like that almost in 100% cases we have to ask them to amend the application, or maybe this would have happened unknowingly somehow. So where the controller is satisfied that the application for any specific other document filed the person does not comply with the requirement of this act, any rules made thereunder, controller may refuse the application or may require application specific other documents as the case may be to be amended to his satisfaction before he proceed with the application and refuse the application to failure to do so. So only in case when actually there is some problem with the patentee, or suppose there is no inventive feature, or there is no actual invention lies in that specification, or maybe what applicant has claimed as invention has been cited by in some document. Only in that cases refusal happens. Otherwise, in most cases, controller gets satisfied, and it is ability of of the patent agent to get him convinced to the grant of patent. So there is another section 16 of which gives power to control to divisional application. So patents are supposed to be filed to be given granted for a single invention. Sometimes what happens that in one patent there are more than one invention. So I'm sorry that this time I have not prepared the actual example to you all, but I'm sure that on that Dr. Singh must have shown you the examples where the division of application may happen. So you can just note down here that controller have power as a remedy to waive the objection or remedy to attend the objection, and you can file a separate patent application with the for separate claim to the other part of the invention to whom we object that this is a separate invention, this is not a common invention. And for that, remember that the new specification should not include any matter not in substance disclosed in the complete specification filed in pursuance of the first mentioned application. That means no new subject you can add, but in existing your specification, and you can get a separate patent for your divisional application. So this is also in the interest of the applicant, because having one patent for more than two inventions, he would have get opportunity to license to a single industry, and single industry can make two inventions, different products, and enjoy enjoy your IPR at a very 50% cost. And if you have two different patents, you can license them differently. Just double money you can earn for licensing those patents. So these are further word by word I have written. The controller may require such an amendment of the community specimen in person either of the community specimen, and explanation for the purpose of this act, the further application and the complete specimen accompanying shall be deemed to have been filed on the date. Yes, date of that next patent will be from the same date as that of the first application, because you are ideally also you are not supposed to claim that I have filed later, so I may be given later date, so I will get more stress of 20 years for protection. No, it is not like that. Date will be considered from the same date. dating, and then there is another power of controller, that because dating of application is very significant for any patent holder. So sometimes date of application also you can shift, and controller have power to allow you, subject to the provision of section 9. Section 9 is simply about this, your qualification for filing patent. At any time after filing the application and before the grant of the patent under this act, controller may, at request of the applicant, made in the prescribed manner. So wherever prescribed manner is written, that means you have to file in certain form and you have to pay certain fees. So you have to make request for this. Then controller may direct that application shall be post-dated to such date as may be specified in the request, and proceed with the application accordingly. And this date is not more than 6 months. You cannot, post-date your application more than 6 months. But less than 6 months, you can make request. Suppose you have filed your application in January 23, so you can post-date it only up to the 30th June of 23, not of 1st July of 23. Maximum 6 months you can post-date it, from January to 30th June. Where the application or specification, including drawing or any other document, is required to be amended under section 15, the application or specification or of the other document, if control so directs, be deemed to have been made on the date on which the requirement is complied. So you see here the cooperation of from the office side to IP users, that this process is very normal, that specification and other documents were amended, deemed to have been made on the, but controller never post-date the application of his own. Okay, because this may later sometime this may be harmful for the patentee also, because person may infringe if he infringes his application before that, or he would have it would have killed his novelty also. So certain powers of controllers are mentioned in the act for anticipation, where it appears to the controller that the invention so far as claimed in any claim or complete specification has been anticipated in the manner referred into a clause A of subsection 1 of section 2 of section 13. Section 13 is to make research, make searches, where examiner has to make search. He may refuse the application unless applicant so to the satisfaction of the controller that priority date of the claim of his complete specification is not later than the date on which the relevant document was published. He has to show that the document which controller is citing, is of the later date to his application. That means somebody may have copied to his invention, or somebody has, repeatedly has worked on his invention. So his right lies first to get the patent. Or sometimes if it is so classic that truly he find that this knowledge was there at that time, then he has to amend his application, his specification. He has to take away that part, or he has to he will not be able, he will not include that portion in claims. He was claiming earlier. He has to delete some claims. He has to delete some portion of his claim. Only then control will be able to get satisfied, and patent application may proceed for grant. So if I go by word, it may take a lot of time. And let me run through. It's already 2:39. So 40 minutes have passed. So power of control in case of anticipation, same thing. If you read, you are all educated people, all are you are faculties, engineers, and students. If you read them word by word, you will be able to understand the spirit of the law. it appears to the controller as a result of the investigation under section 3 that the invention so far as claimed in any claim of the applicant has been claimed in any other company specification that such other company disclosure was published after that unless it shows satisfaction of the control. Tell me, there are all chances that you will be able to satisfy the controller if you are truly claiming your own work. If you have taken some work from the
What is this? Boring.
yeah, shall apply there to the same manner as they apply. Power of control in case of potential infringement. So controls have also powers in case of infringement. Infringement means what you are claiming. If in consequence of the investigations is required under this act, it appears to the controller that invention in respect of which the application for patent has been made cannot be performed without substantial risk of the infringement of the claim of any other patent, he may direct that reference to the patentee shall be inserted. So this means this is just to respect the patent of others. So otherwise, if there will be unnecessarily in conflict of infringement. There is potentiality of that the other patentee will sue the present applicant that he is infringing my patent. Then there will be another difficulty. So better that for that portion which is respecting the inventions of other people should be inserted in that specification, so that any person who is interested in working the invention up to that level, he will contact to that patentee itself. He will not come to this patentee to take license or to make any agreements. So these are all tax matters. The applicant should show satisfaction. The application is amended. He can amend the application, and that other patent is revoked. Otherwise, case ceases to enforce. Suppose other patent revoked, in that case, it is not necessary to mention. So all these things are. It really nothing. Is specific to to teach you all here present here. So similarly, power of controls to make orders regarding substitution applicants. Sometimes in research students, there become conflict between the student and that the person who is heading the research team, faculty or some head of department. Maybe he has not mentioned the name of a boy who has worked a lot for that invention, and left that department and joined some services outside. And now he see that the work which I have done in my laboratory has been claimed by my professor as patent. So in that case, controller have power to execute and call a hearing, and in case only if application has been filed with the consent of the joint applicant, he may consider. Otherwise, he may also direct that there should be another name of the person who has been understood by him that he has also contributed for this invention as inventor. So this is all that no this address will be opposite to be given. There are in certain circumstances where this substitution of applicants should not be so casually done. It should be sincerely done. So for that, has mentioned all these things. One or two or more joint, same thing. It is a continuation. So for co-owners also controller has power to give directions. So just you believe that there are provisions for co-owners also. You need not. I need not to go by line and take your time and make you bored. So I'm just communicating you that powers is there to give directions for co-owners also. So don't worry. if something mishaps, that co-owners of the have conflict with the applicant, they may file request to they may make a request to controller, and controller may fix a hearing and decide about the right of the co-owners also. So this controller has certain power of civil court also. So definitely sometimes it is required and for necessary for the prosecution that we have to summon somebody attendance for examination on oath, or some documents are required which are not disclosed in the specification. Some evidences are on affidavit may also require, and sometimes if something is not properly obeyed by the applicant or by a concerned person, controller may award costs also. Controller may also review his own decision. Suppose he has missed some part before that, before deciding on finality, or he has understood differently and not correctly. A review application can be filed in form by the applicant in form 24, and controller may in that case reconsider his application and decide. Sometimes controller do decision in ex parte. So in that case, if party has come before him and has shown the sufficient reason that it was missed by him unintentionally, then controller can take up the case and decide, set aside his earlier adverse orders and make different orders. So controller have power. Am I audible to all? Hello?
Yes, sir. Audible,
Hello?
sir. Please continue.
Yes, sir. Yes, you are audible.
So I would like to be more interactive. Anybody can. I'm not able to see the hand raise here, but I am able to listen to you all. Anybody can ask any question in between. So because just running these slides may become boring for you all sometimes. So I was talking about the power of controller to correct clerical errors. Sometimes there are very silly small errors. I have in my service time, I have seen sometimes PH in place of PH, somebody has written POH, and sometimes very spelling mistake they have done. So therefore that the controller have power to rectify them as his own, or with the intimation to the applicant, or even applicant may make a request to controller and get corrected his clerical errors in his patent specification. And about the evidence, controller have certain powers. Every evidence is not to be given in one affidavit. Sometimes oral evidence also controller can accept, and in lieu of the or in addition of the evidence or affidavit. So I say that this is not this power is a friendly way to interact with the IP user. Suppose for a small thing, if I ask him to give affidavit, it will trouble him unnecessarily to go to the court and bring affidavit and prepare the affidavit. But controller have power. Controller can simply listen him and get satisfied. Or sometimes controller can also cross-examine some other parties. In a poison case, this may happen that some people just include the affidavits which are not, in fact, so truthful or so technological, aligned with the subject of the invention. So in that case, controller may call them and cross-examine that on what basis you are giving this affidavit, how you are giving this affidavit would have destroyed the purpose of this invention. So for that, this power is available under the Act. And controllers have also been given some discretionary power. So discretionary power means only just to take care of the rightful interests of the applicant. before exercising adversity to the applicant. Discretion vested in the controller by under the Act, provided that the party desiring a hearing makes the request for such hearing to the controller at least 10 days in advance to the expiry. So the time limit is specified in this respect of proceedings. Even sometimes single day also controller allows resolve the issue. Disposal by controller of applicant for extension of time, where under the provision of this act or rules made thereunder, controller may extend time of doing any act. Nothing in the act shall be deemed to require him to give notice to the hear the party interested in opposing the extension, nor shall any appeal lie from any order of the controller granting such extension. So this again, this power is is to accommodate the IP user. But you see that where under the provision of this act, this power doesn't mean that this means that you can do anything. You can extend any timeline. There must be a provision under this act where you can use these powers. Power of controller to adjourn applicants for compulsory license. This is also a power of controller, and I think it will become more specific if I deliberate word by word. You just simply understood that you power of control granting compulsory license. So in what cases it is? First of all, you have to understand what is compulsory license. So a compulsory license at any time after the expiration of 3 years from the date of grant of the patent, any person interested may make an application to the controller for grant of compulsory license on any of the following ground, namely. This happens very rarely. As of now, only single license has been granted to a medicine on these basis of reasonable requirements and not worked in India. So these are 3 requirements. The reasonable requirement of the public with respect to patent invention has not been satisfied. Patented invention is not available to the public at reasonable affordable prices. That the patent invention is not worked in the territory of India. So if this happens, then compulsory license can be given by the controller. Otherwise, in a normal way, licenses to work in inventions are given by the patentee. So sometimes, suppose patentee is not giving for any commercial reason, for any reason, they are not giving license to a person who is manufacturing in India. Because if they manufacture, and this happens in reality also, because where this for single compulsory license was given, the drug was in lakhs of rupees for 3 months treatment. But when it was prepared through industry in India through compulsory license, it was of very few thousand rupees, 8,800 or 10,000, around 10,000. So cost has come down to more than 10 times of the cost charged by the foreign company. But unfortunately, for this happening, there must be a person who is interested to seek a compulsory license. Suppose there is no person, or in case of costly drugs, suppose we don't have infrastructure like that we can manufacture here or work out here this invention. So there is no way to go for the compulsory license also. So that's how now argument have been made that importing of the drug may also be considered as working in the India. But in that case, at least reasonable affordable price and that reasonable requirement of the public should be met. That is required. Power of control to refuse deal with the certain agents. So control have power, but this also does not happen never. Controller also when I understand that controller is to be so humble that he should not consider these things not to deal with the certain agents, and this happens very rarely. power of control to call information from patentee. This is also one of the important power that every year in Form 27, every patentee has to give information to the office that what he has done with his invention, whether it is work or not work. If not work, what efforts he is doing for working of invention. If it is work, then how much money he is getting from that patent, to whom he has licensed the patent. All such things are required under the Act, and every year they have to file. So I have mentioned some rules also. So now I will go as my topic is to streamline that after grant. There are some important things which I think is still not propagated under the users of the on patentee side, because there is a requirement that there shall be supplied to the controller in prescribed manner for being filed in the patent office copies of all agreements, licenses, and other documents affecting the titles to any patent or any license thereunder authenticated in the prescribed manner, and also such other document as may be prescribed relevant to the subject matter. This is the requirement. But we notice that sometimes patentees or licensees, to whom they license their patent, does not comply this requirement just because of fear that in license they have some terms disclosed like that, which they fear that if this is opened, or submitted in the patent office, somebody may take advantage of business advantage and be in a competitive position with them with those informations. But their kind information, the power controller has been given a power that if they request to take a step for securing that terms of the license are not disclosed to any person except under the order of court, they can detect the portion. They can make it black, as they have to give original document of agreement or license. But in that document, they can make it black marking so that they can secure their terms of license not to be disclosed to general public. So controller has power, but nobody is taking advantage of that power. Because they have fear, and because of fear, they don't even make registration and file to this office. And it is very difficult for the office to keep track on those people who are not filing and complying with the requirement of the Act. And there is no provision for punishment also to those people. So I appeal them that they should never worry and they should follow the law, and they can secure their terms of licenses by detecting the portion. They think so important. And these are slides I have made later just to explain any question if somebody asks persons entitled to apply for patent, and provisional specification, what is provisional and complete specification, what should be the contents of the specifications. These are the all subject matter of a book. It is textbook of the Patent Act. Anybody can follow this who keeps interest in further in streamlining the filing procedure of the and preparing the complete specification. They can read this. That what should be the content of the specification. There shall be described invention, shall begin with the sufficiency indicating the subject matter to the invention. Control so requires applied to the purpose of specification of complete provision unless controller otherwise directs to part. If any particular case controller considers that the application should be further supplemented by model or sample. This is also very rarely happening. Controller never asks for models. We believe that whatever you are mentioning is mentioning truly, and your claim is industrially applicable. and it is novel and inventive also, subject to their examination and search, etc. So in detail, there it is mentioned that what a company experience should mention. It should particularly describe the invention and the operation of best method to perform, disclose the best method, etc. You can all these you can read. I don't take your much time here. Exemption of application also mentioned. So I will take up those slides if required in your question answer session. This I have just showing you example of patent certificate, how it looks like, and you can see here. Signature of the controller general is there. O.P. Gupta ji at that time, but now Professor Dr. Unnat Pandit is controller general. He's taking lot of efforts, like this patent awareness and so much work he is doing. So my presentation comes to end here, and be sure that you have taken your share from this presentation. I mean, you are able to peel the orange before you take it back to home. Now I invite you all for any question. Hello.
Yeah, thank you so much, sir. You have given all the precious inputs and ignited the minds. Now, this is the time for the question and answer. I request the participants to ask some questions if they have. Participants, you can ask the questions.
218 participants. I am visible in my desktop. So it's very good numbers, and I think at least 19 questions must be there out of 219 people. And even after that, I welcome you all. I mean, to make any query to my email, and I assure you that I will take it personally and help you. Like these organizers are helping you to make you knowledgeable about the IPR. Believe that after getting patent, there are so many things which are, I mean, you must know that I have noticed sometimes that faculties have received patent, college have received patent, but they have not maintained the patent by paying the renewal fees. They have lost their patents. So it was sort of time I could not mention here one more significant part about this this restoration of patent. If somebody may ask question, I can explain him what is restoration of patent and how this happens. Please raise any question.
Yes, sir. So we have received the patent in 2020. So
Okay.
after how many years we have to renew that patent?
You see, it is like that after you have been given patent, there is a date of recordal. So from date of recordal, even in the patent certificate, you have been mentioned there that within 3 months you have to pay the renewal fees. And suppose you are not able to pay the renewal fees within 3 months, then you can extend it for 6 months also by paying certain fees, and then you can renew your patent. I mean, even if you have missed that 6 months time, you have 18 months time to restore your patent. But for that there is a requirement that you have to give a reason. Unintentional reasons that you were not able to pay the renewal fees in time. Suppose controller gets satisfied if you say that, sir, I was looking commercial value of my patent, so I was not able to pay the fees. This means it was your intention not to pay the fees. In that case, your patent will not be renewed after 9 months. So I repeat, 3 months from the date of recordal is the clear timeline, and after that, further 6 months you can take extension, and after that, further 18 months you can restore patent. Otherwise, after 9 months, your patent will get seized. Seized means anybody can work in your patent. It is now in public domain. So if you are granted patent 20, take care that, I mean, you can inform me your number. I will confirm if patent registration fee has been paid or not paid.
Okay, sir.
Okay.
Thanks. Thank you.
Welcome.
Any other question from the participants? Organizing team, Dr. Shrikant,
Yes, sir.
Dinesh, Professor Dinesh. Yeah.
Yes, sir.
I think there is no more question from participants, sir.
No more questions.
Wow, it was a really
I have
delightful to hear
one question,
such
sir.
a detailed and informative session, sir.
Hello.
I deem a great honor and privilege to propose the vote of thanks on this sixth session of 50P. First and foremost, I thank our today's eminent speaker, Dr. S.S. Singh, sir,
Thank you, sir.
former
Nice
Senior Joint
session,
Controller,
sir.
Patent Office, New Delhi, Government of India. Thank you, sir, for this brilliant session.
Bye bye to you
So
all.
your session was really lavishing. We all really get lots of knowledge through your session. So you explain the things in such a manner that we all get the clear and brief idea of it. So elaborate actually meaning of optimization and streamlining innovation for patent registration, as well as aware us different clauses under section of Patent Act 1970, what measures have to be taken under Patent Act 1970 for filing patent. We are really glad, sir, to hear you. The session was really informative and knowledgeable. Now, on behalf of SPC Mumbai and HSM HSGB COET Bhusawal, I would like to convey my sincere thanks and appreciation to you for imparting us your excellent knowledge and for providing technical skill to our participants through faculty development program. I am obliged to you for your true help. The session was termed a grand success due to your earnest involvement, and we are all inspired by you, your great expertise knowledge. I hope you will contribute in the same manner in the days to come for such activity. And thank you once again for sparing your precious time. Thank you, sir.
Thank you very much. I am always available for all these organizers and colleges. I am always available. Anytime.
Thank you so much, sir. Thank you so much.
Most
We
welcome.
are happy to get associated with you.
Thank you so much, sir.
Welcome, Betty.
Sir, please share the Google link, please.
Dear participant, I would like to inform you that today's second session is over now, and tomorrow's first session will start at 10:30 a.m. with more enthusiasm. Link for
Sir,
the
please,
session will share on WhatsApp group. Please join the session.
please share the Google. Sir, please share the feedback link, please.
The tomorrow's morning session will be taken by Dr. Raghvendra, sir. Thank you.
Thank you. Okay, sir. Bye-bye.
Okay, sir. Bye.
Thank you, Dr. Santosh Rane, sir.
Thank you, organizing team. Wonderful interaction. Thank you. Thank you, all the participants.
Hello.
सांगितलं होतं.
अंदर का ही कुछ तो भी वाइब्रेट नहीं करने पड़ना और आईपी का है हमारे पास भी आईपी का ही है काका उनके पास नहीं होता है सब कुछ
अरे वाइब्रेट होता है
वही पर उसका तो उस
अगर ज्यादा लोडेड हो गया तो वाइब्रेट होता है
मीडियम उसमें नहीं
ये इसलिए मंगाना चाहता था मैं
देखो ये स्पेशल